So today we're filming the videos in response to all the comments we got in the last series of videos. Great comments, great questions. Let me do what I can to answer some of those. So this comment from Zion says, Tory said the prosecutor suppressed all exculpatory evidence in his case. Can he get appeal based on suppressed evidence? So to answer that, what I would tell you is there's two meanings of suppressed evidence, and I want to make sure I answer your question correctly. Colloquially, when we talk about evidence hidden or not turned over to the defense or the prosecutor, that the prosecutor was aware of, but the defense was not aware of until after the trial or so, that evidence was integral to defense. Yes, that is a very valid reason for a new trial. The most famous version of this, I would tell you, is the Ted Stevens federal corruption trial, where the federal senator had been senator forever. They hid some very, very clear evidence, which got him convicted. And then the conviction was actually either overturned or withdrawn by the federal prosecutors when the next federal prosecutor in charge found out exactly how much evidence was suppressed or kept away from the Stevens defense team. But usually when we use the word suppressed, that would be the regular dictionary definition or the colloquial definition of the word suppressed. Usually in court, we don't use the word suppressed in that context. The context we use suppressed in court is when that means that the evidence was found that it was collected in an illegal way. Therefore, the evidence has to be suppressed by the judge at the request of the defense. Usually after likely arguments, you file a motion, you have a hearing, often you'll have evidence will come out to discuss how they collected that evidence, i.e. if they break into your house and take things from your house without a warrant. That's the most obvious suggestion of an illegal search. Anything they find during an illegal search, if the judge finds that it's illegal and that there was no exception to it, then what they will do is suppress any evidence that they find in that context. So that's usually what we call suppressed evidence. Ever heard of fruit of the poisonous tree? That's exactly what it is. The illegal action, the illegal search, for example, is the tree or the seeds of the tree. And the evidence that cannot come into court is the fruit of that poisonous tree. That's why it's suppressed. So if evidence is kept out for any reason other than a legal challenge to the way the evidence was collected, i.e. The legal challenge would be like no Miranda, but you gave a statement. There's no warrant, but you collected evidence. Then we usually use different words. We wouldn't say suppressed. We would say kept out or precluded. Suppressed technically is a very particular way to preclude prosecution from using certain evidence against the defendant. So I guess where I run into trouble in your question, the standard meaning of suppressed evidence would be at the request of the defense. So if I'm not sure what evidence is that he wants to come in that was suppressed, if they hid evidence and that evidence was integral to a defense in his case, for example, he would not be able to explain his defense in such a way that the jury would be able to understand it without that evidence, then absolutely that's a very, very good reason for a new trial.